Society wins not only when the guilty are convicted, but when the criminal trials are fair. That's what U.S. Supreme Court Justice William O. Douglas said in the 1963 case of Brady versus Maryland. Boy, Brady was an important case, I gotta tell you. But in a perfect world, it definitely should not have happened. Why? Because it involved prosecutors doing some of the most stereotypically sleazy stuff imaginable. I mean stuff that TV shows portray. They were withholding exculpatory evidence from a defendant and his attorneys. They were trying to get a not guilty man convicted. They said, oh, this evidence would show that he's not guilty, so we want him to be found guilty, so we're just going to withhold it. What happened was this John Leo Brady guy, he was convicted of murder. He and a guy named Charles Boblet. Now, Brady's defense attorney asked the prosecution, request them to turn over statements from Charles Boblet because Brady was saying, look, I was involved in this, but I was not the one who did the killing. Therefore, I cannot be found guilty of murder. The elements are not there. Charles Boblet did it, he said. Now, the prosecution withheld statements from Charles Boblet admitting to doing this act, doing the killing. And so Brady gets convicted. And Brady's defense counsel, of course, appeals it, saying, hey, due process, 14th Amendment due process clause, this seems pretty unfair. They withheld evidence. So they seek a review from the U.S. Supreme Court, and the U.S. Supreme Court comes down on the right side saying, no, prosecutors, you cannot do that. You cannot do that. They create what's known as the Brady rule. You might have also heard of things called Brady motions. You don't have to be an attorney to know of Brady motions. You might pay attention to just criminal law generally, and that's the idea of, okay, turn over this exculpatory evidence, turn over this evidence that is going to help the defendant show that they are not guilty. Help them show the jury, hey, I'm not the one. I'm not the one who did it. Someone else did it. Something that could help them impeach a witness who's testifying against them. You need to turn over that evidence. So what the rule ends up being is suppressing evidence favorable to the accused violates due process, specifically material evidence. Material evidence, stuff that has a reasonable probability of influencing the outcome in favor of the defense. And actually, this case was not unanimous, believe it or not. It was 7-2. So there were some dissenters, and you might be thinking, what is wrong with the people who dissented? Why on earth would they oppose such a basic moral principle of prosecutors don't be jackasses and make sure to give the defense exculpatory evidence? Well, Justice John Marshall Harlan dissented, saying, well, I'm more concerned about the procedural aspect of this. He was saying that he didn't think that the issue was preserved for appeal, so he's not necessarily saying he substantively disagrees with the majority. But then Justice Hugo Black, who was a former Ku Klux Klan member, did kind of dissent on the idea that why is the U.S. Supreme Court, the highest court in the land, going to be regulating criminal procedure within the states? So yeah, there were some people who unfortunately disagreed with such a basic moral principle. Now, does the Brady rule hold up super strong today? Not necessarily. It holds up fairly strong, but there were some cases that clarified it, that kind of said, well, not so fast. The prosecution doesn't have to turn over all evidence that could feasibly help the defense. There was a 1985 case called Bagley. It was a very close decision written by Justice Harry Blackmun, a justice who started off more conservative and became more liberal. And he was basically saying, well, we don't think that this certain kinds of evidence are material. Material evidence means, again, reasonable probability that its disclosure would have changed the outcome of the trial. Now, the Brady motion is basically the defense saying, hey, prosecution, turn over any exculpatory evidence you have. Turn it over. So you will hear about defense counsel filing Brady motions. A lot of people discuss this. It's one of the first things you want to do. Like prosecutors, don't do this. And the crazy thing is, you would think that prosecutors would actually do that more often. Like, why would they be so obsessed with incarcerating someone, or I guess getting them found guilty? It's not like they're being paid by the state. So it's not like their client, they can't charge contingency fees to the state or anything like that to lock up someone. So it's pretty stupid. It's pretty cringe. And as I said, Brady versus Maryland is 1963. This is a fairly progressive Supreme Court back then. The 70s and the 80s, they ushered in a much more tough on crime Supreme Court. You had President Nixon and President Reagan, and they were like, let's be tough on crime. The drug war also was a big thing, like, big bad narcotics. And so, under the Berger court and the Rehnquist court, there was a big change in how the Supreme Court justices viewed the criminal justice system, and they were like, the prosecutors are actually the good guys here. I have to say, always being really deferential. That Bagley case that I said clarified Brady, that was a great example of that. It was a close decision. Justice Thurgood Marshall, very progressive guy, dissented in that. So there are a lot of progressives who think that some of these modern cases have done some damage to the idea of Brady. They think that, look, if there's any evidence that can help the defense, prosecutors should give it. Prosecutors should give it. They have to prove beyond a reasonable doubt that this person is guilty of the crime. They can't just be like, oh, I'm going to make it easier on myself to meet my burden by withholding exculpatory evidence. You're a government attorney. You're not being paid by a particular client, a particular person. Why on earth would you do that other than to just oppress someone? Just to oppress some criminal defendant, oh, I just think they're a bad person, so I want to withhold evidence. It's really sleazy and really scummy. So yeah, thank the heavens for Brady versus Maryland. This was a very, very well done decision. It is kind of surprising too that it didn't happen until 1963. 1963, 52 years ago, at least 52 years before I made this video. It's a pretty fundamental principle. So you kind of wonder, okay, were prosecutors withholding exculpatory evidence a lot before Brady? Big credit too to William O. Douglas for this decision. He's considered the most progressive Supreme Court justice in history, and he's the longest serving Supreme Court justice in history with a whopping 36 years under his belt. So yeah, this is one of those decisions that everyone should revere. It's up there with Gideon versus Wainwright, which is, essentially the idea that if you can't afford a lawyer, you're entitled to a lawyer as a criminal defendant. Simple, basic humanitarian principles, treating people decently, not just being like, oh yeah, we're gonna throw you to the wolves. Sorry, can't afford it, loser, whatever, deal with it. This is a similar sentiment of, okay, you should not have evidence that helps you withheld from you at your criminal trial. Simple as that. Let me know what you think in the comments below about Brady versus Maryland. I like this case. It was fascinating to read. If you're in a law school class, a criminal law class, you probably have heard of Brady versus Maryland. You're probably studying for a criminal procedure final exam. I hope this video is helpful to you in understanding some of the policy considerations of Brady versus Maryland, or if you're studying for the bar or anything, you're an undergrad studying criminal law. I hope this was helpful to you. Or if you're an attorney or a law enthusiast watching this, I hope this was interesting to you. Please like, comment, or subscribe to the channel. Thank you so much for watching. This is the more the merrier, and I look forward to speaking to you in my next video.